Alrighty, folks, looks like we are live. I'm George with Solo. We help people resolve debt disputes. Have on the show with us today, Greg. Greg, can you go ahead and tell us a little bit about yourself?
Yeah, I'm Greg Anjewierden. I am an attorney. I practice in Salt Lake City, Utah, and I have a company called Debtbrief that helps people find resources for fighting their debt collectors in court.
Fantastic. That sounds great. Thanks so much for coming on to the show today. So, folks,
Yeah, happy to be here.
Great. So we're going to be talking about how to resolve your debt lawsuit. We'll be going ahead and get into some specific topics as well. We oftentimes reserve quite a bit of time for any questions that you have for me or Greg. And if you have questions, go ahead and put that into the chat on YouTube. And we will do our best to get to answering that question for you. For right now, let's go ahead and start off with a couple questions from the audience. So we have a question here from Jersey, wanting to know about credit card debt that is on my credit as it was written off by the credit card company, and all of a sudden I have a lawsuit. Is this legit? What do you think, Greg? Is this kind of thing that happens
So
from time to time?
I get this question all the time because people are like, "Oh, it's written off," and really, like when you talk about it as written off or is charged off, is another way of saying it, is really just an issue for the credit card company and their taxes, right? So like a lot of times what happens is the credit card companies, they don't want to be the ones that are chasing down all the bad debt, so they sell the debt to a junk debt buyer, and then they will write it off or charge it off, whatever. And now it is that the right to collect on that debt now belongs to that third-party debt collector or that junk debt buyer. So really, when it comes to charging off or writing off, is really not something that matters for you when you're being sued, right? Like, I know people are always like, well, it's charged off and I want to make that defense. It's not a good defense, typically, in most cases. What instead you want to focus on was that debt properly sold to the debt collector that is now suing you, right? So if they go to court, they've got to prove, number one, that you owe the money under the original contract, you owe the original credit card debt, and then they have to prove, second, that they own the right to collect on that debt. So do they have the contract that shows the debt was actually purchased? And it's that contract a lot of times that they don't have, right? So instead of focusing so much on, well, the credit card company wrote it off or charged it off, instead focus on, was the debt properly sold to the party that's suing you?
Right. You said so charge off, that's kind of like a tax concept. Do you know how that impacts the creditor? Is that like a situation where they're getting like a tax credit if they charge off this account?
Yeah,
like lost?
So a lot of times, I mean, it could be different for every circumstance, right? So this isn't going to necessarily apply to every time something is charged off. But generally what happens is, let's say you've got a credit card debt of $5,000 and the credit card company doesn't want to expend the resources to chase down that $5,000. So they'll sell that bad debt to, whatever, LVNV funding. Let's say they sell it to them for $500. LVNV funding pays $500 to the credit card company, which means the credit card company has now taken a $4,500 loss. They put that loss on their books, and then it goes as a business loss, which is going to decrease their tax liability, right? Which is why they do it that way. Now, what LVNV does is they've paid $500 for a $5,000 debt. So if they can get more than $500 out of this debt, then they've made a profit on that transaction.
Okay. Does that mean they're going to settle for just $500?
No. and that's another good question. So like, you can certainly try, and I think if they've bought the debt for a lot less, I think that you've got a better chance of settling because they don't have to get a big number to make a profit, right? But really, their calculation isn't necessarily going to be just, are we making a profit? It's also going to be, how much do we think we can get out of this person, right? So, yeah, sure, they would make a profit if you settled it a $5,000 debt for $750 and they paid $500 for it, then they'd make $250. But they sure would rather make $4,500 on this, right? So they'd still rather have the $5,000. So their thought process is going to be more, how much do we think we can get out of this person, and would it be in our better interest to just settle it rather than expend the resources to go after the rest, rather than just say, well, as long as they paid more for it than we paid for it, then we're good with that. They're usually not going to do that.
Right. Okay, great. So the topic of the webinar today that we notified everybody who's here about is how to legally resolve debt, getting attorney tips. So one of the questions we have here is, how can I get out of debt legally? So kind of building on this, like how should somebody get out of debt, generally speaking?
Just generally speaking, how to get out of debt? Well, I mean, we could talk about budgeting and all of these kind of things, but we're here talking about solo and how to resolve these debts when you're getting sued and things. Really, I think there's a couple of ways to do this. Number one, you can fight your case, right? Like, you can use solo, you file your answer, defend your case all the way to the finish. And if you win your case at trial, you don't owe that debt anymore. Or if the case gets dismissed, you don't owe that debt anymore. So really, they can come after you and allege that you owe this debt until they go to court and get the judgment that says that you have to pay this. You technically don't have to pay. Now, there could be ongoing interest and penalties that eventually you may have to pay by not doing it now, but you really don't have to pay anything until you get that judgment against you. So that's one way, is you can just fight your case all the way to the end and win it. I think the other way of getting out of these debts, and by far the most common way, is settling the cases, right? And we've talked a little bit about that a moment ago, but basically they're saying you owe a certain amount. You're maybe saying you don't owe, or you don't owe that much, or maybe you owe, but you don't have the money. And can the two sides, can you and the party trying to collect from you come together and reach an agreement that says, yeah, they'll accept a lesser amount than what's claimed? And that can be for a lot of reasons. Maybe it's because you don't have more money and they know they're not going to get more out of you, or maybe they're missing documents that they think they'll need to win their case, and so they know there's some risk they could lose, and you don't want to spend the time to go to court or whatever. So, settling that debt, I think, is probably the most common way of getting out of those debts.
Nice. Great. We have a question here. I don't know if you know anything about this. What is the 777 rule for debt collection? Ever heard about that?
I have not. I'm curious if you know what that is.
I have no idea what this question is. I have no idea. If anybody knows what the 777 rule is for debt collection, put that into the chat and help us out, help everybody out. How about this one? Is there a legal phrase to stop debt collectors from calling you or anyone you know?
Say that one more time.
Is there a legal phrase that you can use to stop debt collectors from calling you or anyone you know?
I mean, I think, I don't know that it's like specific phrase, but you just tell them to stop contacting you. Send a stop collection letter is really what you're going to do, right? And there's plenty of resources out here. I don't know if Solo's debt verification letter includes that language in there or not. You'll have to tell me. But a lot of debt verification letters will include language that says, like, do not contact me anymore.
Yeah, what we've been doing is with Solo, we've been helping people settle more with collectors. We've been trying to make that process pretty painless for both collectors and consumers, and really just streamline the process between them. I think the way we think about it is that ultimately consumers and collectors want the same thing, which is to settle for the ideal amount as quickly as possible. So with that, we're really just trying to move towards doing that in a streamlined fashion, so we don't have the cease and desist in a debt validation letter.
Okay.
Because of that.
Well, so that brings up a good point, though, because I know a lot of people are like, just send the stop collection letter, right? And you can definitely do that. If they're just like bugging you to the point that like you just can't take it anymore, send the stop collection letter. But what usually happens after that is then they turn around and sue you because they can't bug you anymore, right? And so kind of it can be like this way of like the rubber meets the road. What I say usually to people though is like, why do you, yeah, I understand you don't want them to just keep bugging you, but you don't necessarily want to turn off the communication, right? Like you talk about solo settle and how it's like helping people settle cases. And like, I don't think you ever want to turn off the communication completely. I do think sometimes it can be helpful to send that stop collection letter, and then maybe the debt collection firm or whoever has to give that case to an attorney, and then you can negotiate with that attorney or use solo settle ideally to negotiate with that attorney, because I think it's a lot easier to communicate with a lawyer than it is with a debt collector.
Right.
But yeah, I definitely, how can you stop them? It's a stop collection letter, but again, I don't think you want to cut off communication completely, because ideally you want to resolve this. That's not going to stop this from coming. Right.
Yep. And what we found is that the closer the debt gets to the end of the road, the higher the settlement rate will be, or the higher the settlement proportion will be. So actually, like collectors, right, if you send a cease and desist before a lawsuit and then the collector sues you for the debt, they're actually only going to be willing to settle for maybe like 60% of the debt, whereas before they sue you, they might be willing to settle for 40% of the debt.
Yeah.
But the settlement proportion increases as their costs increase, right? Because once they sue you, they've had to pay for the law firm, so they're probably giving maybe like as much as 20% of what they collect to that lawyer that they're paying to sue you. And then if they have to do garnishment, they're going to have to pay additional fees to the court to garnish someone's wages, as well as probably increase the percentage they're giving to the collection lawyer. So really, the earlier you can settle after charge off, usually the better.
Yeah, and I tell this to people too, is that like, a lot of times you've got this debt collector calling you and maybe you want to settle it and they won't listen. Like, don't get discouraged if it can't settle early, like before you get sued. Like sometimes it just takes working its way through this process, right? Because most people don't file answers and end up in default judgments. They know that. They think you're not going to file an answer. Right. So just sometimes it just takes working through that process. Let them sue you, file your answer, go through some of that discovery. And then like cases, if you're working this case, if you're defending the case, cases have a way of working themselves out, right? Like you mentioned. Right? So like just because they won't settle it now doesn't mean they won't settle it later when they realize they've got more work to do, or maybe some of your defenses have been pretty good, or maybe they're just tired of chasing you down. Right? So just remember, like the case can be settled at any time. Even if it's not settled early, you can settle it later.
You can definitely settle it, right? Even after garnishment, even after garnishments begin.
Yep, anytime.
Yep. Okay, let's see. We have another question here from Jim. If I continuously record a debt collector in North Carolina, since it is a one-party consent state, does that make anything said admissible? I guess he's saying if I record the debt collector on the phone.
Is it admissible in court?
Yeah.
Okay, so we're getting into like real legal stuff here. So assuming that it is legal for you to record the conversation, can you then play that in court? I guess it probably depends on the purpose for why you want to play that recording in court. But generally, if it is the debt collector and the debt collector is the party suing you and they admit to something in that phone call, then that's going to be an admission against interest that would qualify as a hearsay exception and would allow that recording to be played.
It would.
Theoretically.
The recording could be played.
Theoretically. I mean, I got to put like a huge caveat here that like it is really going to depend on the specific case and what is said in the recording and the purpose that you want to play the recording. Right. But let me give you an example. Like maybe you're talking to them on the phone and you're like, I want the original contract that shows that I owe this debt. And they say, we don't have that. Right. So now you've got the party in the case, the plaintiff is admitting that they don't have a key piece of evidence. And now you want to prove that they don't have an original contract. Well, because it's an admission against their own interest, it's now a hearsay exception and therefore could be played at trial. Again, subject to your state's laws. I'm speaking pretty generally, subject to your judge, but under some circumstances it could be played.
Right. Yeah, I've never had a evidence question on here before, I think. So it's fun.
Yeah, that's a pretty unusual one.
Right. Yeah, and I will say, a couple things that we've seen at Solo is that most states are actually a one-party consent state, meaning only the person who hits the record button on the phone call needs to consent to being recorded, right? So basically, if there's two people on a call, one of them hits record, that's all that's necessary to record a phone call. Most states are actually like that. I think there's generally kind of like paranoia about recording people. Like most people think you need to tell people you're recording them. Actually, not the case in most states. So that's been interesting. Also,
I think.
Apple,
go ahead.
I've noticed that Apple iPhone has recently added a record option very prominently on all of their phone calls, which is new. So like recording phone calls has never been easier. So now you can rest assured. I mean, collectors tell you, I think pretty much every time you call them, that they're recording the phone call. They're definitely recording the call. Now, if you are calling a collector, you can record them very easily, free of charge, actually, on Apple iPhones. So that's pretty interesting.
Yeah, so I think where maybe this would be a more common thing is maybe if you're trying to catch them in a Fair Debt Collection Practices Act violation and you record that call, like that is probably going to be allowed to be in court. However, I think the bigger concern when it comes to recording is actually the reverse, where you get recorded by the debt collector. So for example, you're talking to them and maybe you're trying to settle and you say something like, look, I just got on hard times. I couldn't pay my bills. I just want to get this taken care of. Will you take this amount? And they say no. And now they've got you saying, I got behind on my bills. I didn't pay this. Can that recording then be played in court?
And usually, right? Usually like settlement negotiations are inadmissible, right? Usually.
And that's what I was going to say is you're going to argue in that specific instance that this is a settlement negotiation and therefore should not be admissible.
Right. Fascinating. Okay, we got another question. This is actually the reverse, but it might be an interesting question to take. We have a question from CEO. How do I collect the judgment from an LLC that only uses Cash App?
Okay, are we helping debt collectors now?
Yeah, I'm not sure. No,
I'm going to answer this question in the inverse, as like, okay, I'm trying to protect my Cash App.
Well, sometimes we get like kind of really small business owners that are basically like practically consumers trying to collect like a debt from somebody.
Yeah, so let me talk about Cash App.
Yeah.
Cash App's going to be treated the same way as any bank account, right? So generally, if I get a judgment, and this is all, again, caveat, it's all going to depend on the laws of your state, right? So you've got to follow the process that's specifically set in your state. But generally, you can levy a bank account. So I have a judgment. I go to the court. I ask for an order that gives me permission to take money out of a judgment debtor's bank account. A Cash App is going to be a bank account. So you can get your garnishment order or your levy or whatever and take that to Cash App and say, this person has money in this account. Please give me here's the court order that says I can take all the money that's in there.
Right.
Now, so that I think answers the question is you're going to treat that Cash App just like a bank account. For someone who's being sued by creditors, understand you cannot hide your money in a Cash App, right? I mean, they don't always come after Cash App, but like they have ways of getting at your Cash App or your Venmo or your PayPal, just like they can get at your bank account.
How would they do that? Cash App is Square Cash, right? I think that's the peer-to-peer payments app owned by Square, I believe is what we're talking about. How do they?
So I actually have gotten this question before, and I've looked it up on Cash App's website, and they say right on their website that they will honor like bank levies and garnishments.
But how does the collector find out that you have money in your Cash App?
Oh, how do they find out?
Yep.
I mean, first of all, if you're doing things like putting your Cash App on social media or something, now maybe they don't know how much is in there, but like they can do digging and find out that you have a Cash App and what your handle is, right? The other thing they can do is, in some states they can do like judgment debtor exams where they have a judgment against you and then you get a subpoena. You have to show up in court and answer questions under oath about your assets, right? And so they could bring you into court, ask about your Cash App, what's the handle, etc., and then they get the information that way. I think those would probably be the two common ways I could think of that they could get that information. But again, if this is a person that's got a business that keeps their stuff in Cash App, I don't think it would be hard to find. Just a little bit of legwork could figure out.
Because if you have like your e-commerce store online and the Cash App link or something like that, right?
Yeah. Right. Or, I mean, they'll do something like hire a private investigator to go through the process of becoming a customer of your company, getting that Cash App link, and then handing it over to the debt collector, right?
Yeah. Yeah, I think actually CEO had some other messages. I'm not super sure if they're a small business owner trying to collect or if they're actually being sued. I think they might actually be sued by somebody here. Well, let's see. We've got another question here. Somebody stated that the 777 rule is that a debt collector cannot make more than 7 calls within a 7-day period to a consumer regarding a specific debt.
Okay.
Does that sound true to you?
Yeah.
Is that right?
Yep. Yeah. And so I mean, you're talking about like different states and Fair Debt Collection Practices Act stuff.
Yeah. I don't think the FDCPA says that. Right?
I don't think the FDCPA says that, but there may be other state laws and things that talk about that. But regardless, what you want to do, I think, in situations like this is you should be I think the important thing to note about this is you should be documenting every time a debt collector is contacting you, and every time a debt collector is contacting you, and what the content of that conversation is. If you have the ability to save if you record it and save it, like you should just be keeping track of all this stuff, right? Then you're going to the Fair Debt Collection Practices Act and looking at all of the ways that they can violate it. And now you've got your own log of every time they've contacted you, what they've said, what they've done. And now you've got good evidence. If they have violated Fair Debt Collection Practices Act, then you've got your proof of it because you've kept your contemporaneous log.
Right. Yep. You got to keep notes, right? Got to keep your records. Yep. Okay. Let's see. We got time for one more question here, pretty much. Does solo settle apply? This is from Patty D. Does solo settle apply to debt that is in litigation? Yes, it does, Patty. You can use solo settle to settle debts that are in litigation, as well as resolve debts that are pre-litigation that you haven't been sued for yet. All right, that's half past the hour, so that's pretty much all the time we have for today. Greg, thanks so much for coming on. Where can people find out more about you online or use your services online?
Yeah, you can find all my stuff at debtbrief.com, debtbrief.com, and there you'll find links to resources. You'll find a link to Solo, if that's helpful, as well as like my YouTube channel and stuff like that.
Okay. Yep. And I'm gonna put a couple links into the chat here. All right, folks, go here if you want to respond or settle. I'm just going to put that link into the chat. And here is a link to Debtbrief. All right, so you can go to those two places. Let's put those links into the chat. Also, wonderful Hannah has been helping us out and responding to your messages on the chat as well. So if we don't get to your question here, you can come back next week, or you can take a look and see if Hannah or Solo in the chat got a response to you in the YouTube chat. All right, folks. Well, thanks for showing up. As always, we're rooting for you. and Solo helps collectors connect with consumers to get these cases